Hello, welcome, and thank you for your willingness to help the Metropolitan Tribunal as court experts. What I'm going to do is to give you a brief introduction to the role of the court expert, in Latin the peritus, who's the expert in a case of matrimonial nullity that helps the court to understand if there is any psychological anomaly that can influence the person, that did influence the person at the time of the wedding. So as a general introduction, so the role of the expert as a metaphor, I would say, is like imagine the expert in a criminal case, right? They bring in, they have a suspect of murder, someone who's defending from an accusation of murder, and they bring in this guy who knows a lot about guns and says, well, there was gunpowder remainings in the hand of the person. This is the type of gun, that the ballistics, that, right? This person that comes to the stand and gives us an expert's testimony. So it's not an eyewitness, it's someone who knows a discipline that the judge is not an expert in, and is giving the judge knowledge that the judge doesn't have, and that's your role. So in a case of matrimonial nullity, many times we canonical judges need the help of psychological experts. That's where you come in. So I think the very first thing we need to keep in mind, especially for you who are experts in psychological sciences, is that we are here talking about legal stuff. Okay, so this is not counseling, this is a trial. So we're talking about laws, about rights, about contracts. Okay, the mindset is different. And I think this is one of the most important things for you to keep in mind as you start this new role. Okay, so typically, when you are doing your job as counselors, you in therapy, you welcome the person and you try to understand what's wrong, right? And how can I help the person to do better, okay? That is not what we are looking for in a case of declaration of matrimonial nullity. Okay, of course, we care about the well-being of the parties, but that's not our perspective. What we are about is to try to understand if there is an anomaly, in this case, something that made the marriage invalid. Typically, okay, as far as I know, and of course this is your expertise, not mine, but typically a psychologist, a psychiatrist, a counselor, a therapist has a standard of maturity, of capacity that is way higher than the canonical one. Okay, the canonical maturity is a bare minimum, is the minimum that allows you to establish a contractual relationship. This is the minimum we are looking for, is not that minimum to live a happy, successful marriage. Okay, that's different, and it's important that you keep it in mind as you enter this new service to the church. Okay, so that being said, with this preamble, the first thing is that marriage is a contract. Okay, I know this can be challenging for some, but that's the truth, and that's how the Catholic Church understands marriage. Marriage is mainly a contract. Marriage is a partnership between a man and a woman by which they exchange with each other the right to have sexual intercourse and therefore to bear children and raise them together. Okay. This is what we call the covenant of marriage. When two spouses are baptized, that covenant is also a sacrament, right? So, and by the way, this is a common misunderstanding. This floating around in many parishes, even you can hear some priests saying things, the likes of marriage, when it's a civil marriage, that's the contract, and then when you marry in the church, that is a sacrament, and that's incorrect. Okay, there is but one marriage, the contract of marriage, that when celebrated between two people who are baptized, so when both spouses are baptized, that contract is a sacrament. Okay, marriage in this sense is a very special sacrament. So it's the only sacrament of the seven sacraments that existed before Christ instituted the seven sacraments. So there was baptism before Christ. Okay, Saint John the Baptist made baptisms before Christ. there was Eucharist in a sense, so there was Thanksgiving, and Melchizedek offered bread and wine, but those things were not our baptism and our Eucharist. Okay? The baptism of Saint John the Baptist, or the common baptismal practices of the Jews of the time, if you go to the Holy Land, is full of baptismal pools where they enter down the 7 steps of conversion and then come up. Those baptisms are not the immersion in the death and resurrection of Jesus Christ, the insertion in the Paschal mystery. And those offerings were not the Eucharist, by which we enter in communion with the sacrifice of Christ and we make actual that sacrifice in the altar. Those are different things. However, marriage is the same contract, is the one that Christ raised to the dignity of sacrament. In this sense, marriage is a very special sacrament because it is a contract and it follows all the legalities of a contract. For instance, you can celebrate this sacrament by proxy, right? So you can be in a country and someone that has been delegated by you to issue the consent on behalf of you can issue the consent somewhere else in a different continent, thousands of miles away, and you are administering the sacrament and you are receiving the sacrament. Okay. So please keep in mind, because I understand this is a very different perspective, this is very legalistic, very judicial for you guys, that marriage is a contract, okay? And the essence of marriage is that marriage is a partnership that is stable, and in this partnership, which is sexual in its nature, the man and the woman give to each other the right to sexual intercourse and therefore the right to bear children and the obligation to raise the children together. That is what marriage is essentially. Marriage is not only that, but essentially that is what marriage is. As any other contract, marriage can be null, can be invalid. You can have, I don't know, for instance, you can sign a mortgage or you can purchase a car under the influence or at gunpoint. Someone is threatening you. Those contracts are not binding, are not valid, they are not true contracts, they are null, and they could be declared invalid by a judge. So if I am, I don't know, if I am drugged and I do something stupid while I'm drugged, like for instance buying a Ferrari, I can always go to the judge and say, hey, declare the nullity of this contract, because as you can see in the security cameras, I was jumping all over the place. I was under the influence of a roofie, for instance, right? And since it can be invalid, we in the Catholic Church do declare marriages invalid, and we do it actually quite often right now. The nullity of the marriage can come only from 3 sources. So there are only 3 things that can make a marriage invalid. The first one is the lack of form, the canonical form. The second are the impediments, and the third, which is the biggest one, is the defects or vices of consent. Okay? So canonical form was imposed by the Council of Trent, right, as a public form that is binding for the validity of the marriage. Before the Council of Trent, it was possible to get married in secret. So it was forbidden to do it, but it was binding. So, for instance, if 2 people are compromised, they are engaged, so to get married, and they have sex that was understood as the actual getting married. So that gave rise, of course, to many problems. For instance, just to give an example, a wealthy person dies, and then a lot of people come up saying, no, this person was married to me, I'm the rightful heir of all the money. So the Council of Trent mandated, from now on, if you want to get married, you need to do it, you need to exchange the consents in front of the priest with 2 witnesses, and that's what we call the canonical form. So if you don't follow that canonical form and you're Catholic, you're not getting married. That's why the merely civil wedding of a Catholic is considered not binding for us. There are also 12 impediments, which are laws that render a exchange of consents invalid. For instance, the impediment of age. For women under 14 and for men under 16, Doesn't matter that you live in a place where this is normal, or that you are extremely mature for your age, doesn't matter. That law, the impediment of age, makes your consent invalid. You are not going to have cases of lack of canonical form or of impediments. I'm just telling this to you so that you are aware that these things exist, but for these cases, we don't request your help. The third reason why the marriage can be invalid is the defect of consent, okay? The vices or defects of the consent. Consent is the only thing that creates a marriage. The exchange of the consent of the groom and the bride, with consent is an act of the will, and that exchange by which they express that act of consent with their words, when they say I do, right? However, the consent is not the words, the consent is the act of the will. The exchange of consents creates a marriage. In Latin, consensus facit nuptias. The consent makes the wedding. And therefore, because consent makes marriage, that means that the consent lacking something essential is invalid, and therefore, if the consent lacks something essential, if there is no consent, there is no marriage. And this is where you come in. There are cases in which the consent is invalid due to an incapacity created by a psychopathology, by a psychological anomaly. And then is when we need you to explain to us what the anomaly, the psychopathology was. Okay? But before I explain that, let me explain the anthropology behind, or the understanding of the human nature that is behind the laws of the church on this regard. Okay? Because as you know very well, there are psychological schools that are not that cannot be put together with a Catholic understanding of the world. Our laws, the canonical law, requires you, experts of the court, to have a Catholic anthropology, so a Catholic understanding of human nature. And this is very important. It needs to be checked. So not anyone, not any psychologist can do this work, right? So let me just give a few notions. Probably this is going to be more or less known to you, but just to be sure that we are all on the same page. Okay. So our understanding of human nature in the Catholic Church was formulated by Aristotle before the Christian era, and received by the scholastics, mainly by Aquinas. And of course, I'm making this too broad, too general. This can be nuanced very much, but I'm going to be very, very, very broad. Okay, I'm going to paint with big strokes here. So we understand that we humans are the zoon logonechon of Aristotle, so the animal that has logos or reason, in the sense that we share with our animals our sensible nature with other animals. Okay, we are animals, but we are a very special animal. We are an animal who participates with God in his reason. Like the angels, we are the only beings in the creation who have this participation in the logos. Right? The angels are immaterial, they don't share with the animals, but we are animals and we also partake in that rationality of the divine. Right? So as animals, we have sensitivity, we have senses, we have sensuality, we have emotions, and as participants in God's logos, as rational beings, we have reason. This changes our way to receive the world and our way to tend to the world. So as animals, we are sensitive, we are sensible, we perceive the world through our senses, but as rational, we have intellect. We have the capacity to intus legere, hence intellect, to read inside of reality. That's why we can do abstraction. And that's why we can know that a red table that is round and a black table that is square and a blue table that is octagonal are all tables. They are very different materials, colors, sizes, shapes, but we have the ability to abstract, to read inside of the reality, and to make that wonderful thing that other animals cannot do. There is abstraction. So we are able to take in the world in a rational way. And like animals, we tend to the world with our appetites. So we have emotions that move us. So the impact of the world moves us outwards in a sensitive way. So we appetite, we desire, we want delicious food, for instance, right? Like animals do. We salivate when we're hungry, and we have thirst, and we have sexual desires, and we have impulses, and we have anger. It's that, but also we have a rational appetite. We have the will, which is different. So animals cannot have that. Don't have that. Animals, for instance, a dog that is hungry and has food in there, it will be only stopped by force. As opposed to us, who, I don't know, it's Good Friday, you are fasting that day, and you go walk next to a restaurant where they are cooking delicious food, and you are dying of hunger, but because you are a reasonable being, you are a tzon logonechon, you can control yourself. So you have will, and you have willpower, so you can refrain yourself from eating. You can dominate your impulses. You are your own master. You are not like an animal driven by your impulses. Okay, so this way of understanding human nature as sensual and rational, and that we receive the world both through the senses, but also thanks to our reason, we can understand intellectually, reasonably, the reality. We have intellect, and that like animals, we tend to the world emotionally, but also as participants, like the angels in God's reason, we're able to tend to the world rationally, is the basis for understanding the laws of the church on matrimonial consent. Okay, so that being said, let me go back to the grounds of incapacity. I was saying there are three sources for matrimonial nullity: the lack of form, the impediments, and the vices of consent. The vices of consent, the defects of consent that render it null, are things that if they are missing, if they are lacking, you don't have a consent. For instance, the exclusions. So if marriage is the agreement of a man and a woman to establish a permanent partnership, ordered through sexual intercourse to procreation, if you take one of these elements out deliberately, you are not getting married. For instance, you say, I want to marry you, but I don't want to have kids. I hate children, they smell funny, and they are very expensive. So unless children are out of the picture, I am not marrying you. That may look like a matrimonial consent. They may do a big wedding, but they are not getting married because the contract they are establishing is not a matrimonial contract, right? Because contract is marriage is essentially ordered to the procreation of children. So, and by the way, this is not that they were not thinking about it. They were thinking about it, and they were deliberately excluding it from their consent. That is not a valid consent. There is an essential element missing, therefore they are not getting married. Similarly, there are some errors, right? So again, marriage is an act of the will. So if something is missing from the will, or something is essential is missing from the intellect, so if there are some errors of there is the ignorance of something essential, again, you are not getting married. For instance, someone who gets married and has no clue at all about sexuality. They don't know that they are gonna have to have intercourse. They don't know that the genitals are gonna need to be in touch. That person is not consenting to marriage. That person is ignorant, is unaware of something that is essential to marriage. Okay. For these, for errors, for exclusions, for other defects of the will, like for instance violence that is inflicted upon the person, for those things we are not going to need your services. You may see those grounds in the cases that are sent to you, but we are not asking you about those grounds. We will ask you about incapacity grounds. Okay, the incapacities are contained in Canon 1095 of the Code of Canon Law. Let's read it. The following are incapable of contracting marriage. First, those who lack the sufficient use of reason. Second, those who suffer from a grave defect of discretion of judgment concerning the essential matrimonial rights and duties mutually to be handed over and accepted. And third category, those who are not able to assume the essential obligations of marriage for causes of a psychic nature. I'm going to explain these three things. First of all, we need to keep in mind that we are talking about incapacity, that is, natural inability to establish the legal bond of marriage. We're not talking about a difficulty that someone has. We all experience difficulties to live a healthy marriage, to be good husbands and good wives. That's not what we're talking about here. This is not about difficulty. This is about incapacity. Okay? The person is incapacitated for marriage. Okay? Now, the three grounds can be divided in two groups. The grounds of 1095 first, number first, and number second, that is the lack of sufficient reason and the grave effect of discretion of judgment, are grounds of incapacity in that the anomaly messes, impairs, renders invalid the act of the will. So it messes with my ability to understand what I am doing or to freely choose it. Okay, so in numbers 1 and 2, the problem is that the anomaly is impeding the formation of the act of consent. On the other hand, in 1095.3, the incapacity to assume, what happens is that the anomaly is impeding me from fulfilling what I am promising. And because no one is bound to the impossible, I cannot say yes to something that I cannot do. I cannot commit to something that I am incapable of doing. So there is a difference in how the grounds work. Okay. Now, the first ground, let me explain them one by one. The first ground is a very old ground. It has existed since centuries ago under the name of amentia, or lack of mind. No, mens, mind. Amentia, or lack of sufficient use of reason, are cases in which the person is heavily incapacitated for any kind of contractual relationship, any kind of legal act. So that's the case, for instance, when they have an epileptic attack, when they are drunk or under the influence of other drugs, right? So in these cases, it's very evident that the person was incapacitated, and we will also not be asking your help. I mean, maybe in one case, but typically for 1095.1, we don't need an expert. So if the person is drugged during the wedding and is showing effects that are very clear, and the judge typically doesn't need an expert to explain how that happened. I mean, it's very evident for everyone. In 1095.2, grave defect of discretion of judgment, we typically ask for your help. By the way, even though there are many grounds, many themes, many sources of matrimonial nullity, and there are also within the third source, the vices of consent, there are many different grounds. The grave defect of discretion of judgment has become the queen of the grounds. So I believe in our tribunal, we have a 60% of cases that are considered under this ground. So this ground is very common, and this is when we ask for your help. Okay. The grave defect of discretion of judgment, similar to the amentia or insufficient use of reason, is a ground in which the anomaly touches on the capacity of the person to create the act of consent, but it's not so evident, it's not so manifest. Maybe the person is able to function in other ways as a member of society, or to create contracts, to work, to be productive, etc. But the anomaly impedes the decision-making process, the capacity to understand and to process thoughts correctly, or attacks the freedom of the person more directly. However, it's not so evident, and that's why we need a professional of the psychological sciences like yourself to help us. Okay. There is another name or subset of this ground, which is the lack of internal freedom, right? which again is the same thing as grave defect of discretion or judgment, but we call it lack of internal freedom when the anomaly touches more on the will. It's very evident that it touches on the will than in the end on the intellect of the person. I'm gonna give you a couple of examples so that we all understand what I'm talking about. So imagine a poor immigrant who comes from Mexico, is living here, and feels extremely lonely. So he's washing dishes in a Chinese restaurant, so he's surrounded all day long, very long hours, 14 hours of work a day, surrounded by people who don't speak his language. He feels extremely lonely and is heavily depressed. So this gentleman goes home every night, and through Facebook he reconnects with this old friend from school, and he focuses on her, like with a tunnel vision, all his hopes of happiness, and falls desperately in love with her. And this is a woman that he would have never looked at for any other reason. If he was in a different circumstance, he would have never paid attention to her. They are a very bad match. They will not get along very well. But because of his depression, the driver is the depression, he does everything he can so that he's able to bring her to the United States and so that they can be together, and he marries her. Okay. In this case, it's evident that it was the anomaly, in this case the psychopathology of the major depressive disorder, that was governing the whole process and that was impairing his ability to understand what he was doing. So if he had been in a healthy situation, he would have never committed to this marriage. Okay? So this would be a typical case of grave defect of discretion of judgment. So the judgment was impaired by a grave defect of the discretion. The discretion is how thoughts discur, right, from one thing to the next. And in this case, without the major depression, the person would have said, what am I doing? I mean, this is crazy. I mean, I'm not even attracted to this woman. Why would I marry her? Okay. Another example, in this case, it would be more affecting the will, right? Imagine, I mean, I'm talking about real cases, so I'm telling you imagine, but they are actually cases that I have had to consider as a judge myself, right? Young girl in her 15 year of age, she has a boyfriend and they have sexual intercourse once, and she breaks up with him. And then some months later, in the celebration of the patron of the village, a friend of the boyfriend, the former boyfriend, walks up to her and say, hey, why aren't you with Roberto? And she says, well, we broke up. And then he looks suspicious and says, well, in my mind, once a woman has been had by a man, she should be had always by the same man. So she immediately understands that her ex-boyfriend told his friend, this guy who's talking to her, that they had sex, and she's terrified. So this woman, this young girl, was very anxious. She was raised in a very strict home where she was always taught that a woman only leaves the paternal house dressed in white to create a new home, where she suffered from anxiety. She was very nervous. So immediately after this experience, she goes, finds the ex-boyfriend and convinces him to marry her. In this case, it's the anxiety that's driving her. She didn't even want to be his girlfriend. And now, because of the fear, of the terror that they are gonna know, they are gonna throw me out of the house, I'm gonna be derelict, I'm gonna suffer. So moved by her fear, by her anxiety, she proceeds to this wedding. So it's clear that the psychopathology is messing with her will. So the will is limited substantially, and that is an instance, an example. These grounds of incapacity became more popular in the church. Now they are very, very common. We use it very often in ecclesiastical tribunals all over the world, but they began in the 1950s with very grave cases of psychosexual pathologies. For instance, a man who had a psychological issue that made him go with prostitutes. So even if he promised to be faithful, he couldn't because of his disease. And this brings me to the third ground, the incapacity to assume. This that I just explained would be a case of incapacity to assume. The general principle, this is a legal principle, is that no one is bound to the impossible. Ad impossibilia nemo tenetur. This means that nobody can validly promise something that is impossible. So for instance, if I promise you to give you $1,000, it's going to hurt me, but I owe you $1,000, unless I was doing it with a gun to my head or something like that. If I promise you, I do owe you what I promised you. But if I promise you something that is impossible, if instead of $1,000, I promise to give you all the gold in the world, that promise is void, is null, because no one can put together, not even the US government can put together all the gold in the world. Or if I promise to take you in my shoulders and bring you flying to the moon, that promise is nothing, because I cannot do that. I cannot fly, we would die in space on our flight to the moon. So because no one is bound to the impossible, those who are incapacitated to fulfill something essential to marriage cannot marry. Okay, so this is the third ground of psychological incapacity. Those who, because of a psychopathology, cannot fulfill something essential, like in the example I just gave, the duty to be faithful, they cannot marry. Okay. Finally, note that the incapacity needs to be present at the time of the wedding. So it is very important, and we will ask you about that the anomaly was present at the time of the wedding. So sooner or later, we all become, due to old age, incapable of marriage, right? But this is not what we're concerned with. So for us, the matter is whether you were incapable when you were getting married. Okay, the incapacity needs to be present at the time of the wedding. As you can see, everything that we ask you is about the anomaly. Okay, I know anomaly is a loaded term, but when we speak of anomaly, we're using a canonical term. There is like an understanding in the Catholic Church that there are things that are anomalous, right? And there is like a notion of normality, right? So the abnormality is what, I mean, it's not exactly the same, but is what you refer to as psychopathologies. So we are not asking you about we're not asking you whether the person was capable. We're asking you whether the person suffered an anomaly, because the capable part is for us judges to decide. What we want from you is the information you can give us regarding the anomaly. That's the thing we don't know about. We know about loss, we know about capacity, but we don't know about psychology, so we need your input. Okay. The anomaly is a requirement for the incapacity to exist. Without anomaly, there is no incapacity, but it's just a requirement. The anomaly is not the incapacity. You can suffer from psychopathologies and regardless be capable of marriage, right? So what we're going to ask of you is tell me everything you can tell me, in this case, about the psychopathology, about the anomaly, okay? And this anomaly needs to be grave. So not anything renders the person incapable. The anomaly needs to be grave. Of course, as we were saying at the beginning, you psychologists are always trying to help the person, and for that you're trying to identify, okay, so what's the problem with this person? Well, you can do this better. That's not what we're asking. So what we're asking is, was there a severe problem? Was there something heavy here? Was there some important problem hurting the person at the time of consent? Okay. So when we have a case of incapacity, we will ask for your help, and in those cases, you will give us your input, and we, the judges, will decide whether the person was capable or not. So these two roles must be kept distinct. Okay, we are in symbiosis. We are cooperating, but your job is to tell us about the anomaly. Our job is to speak about the validity of the matrimonial contract, right? In this sense, a bit pretentious, if you want, we call ourselves the expert of the experts, the peritus peritorum. Please forgive the expression. Okay, typically you will share with us your knowledge in a report that we call the psychological evaluation. You will be assigned by a decree by the judge as the expert in the case, and then we will send the person, the party that has been accused of being incapable, accused in a legal term. Of course, there's no judgmental approach here. We are not judgmental with the behaviors of the people. We only care about whether the marriage was valid or invalid. That's our scope, okay? But legally, you speak of the person that has been accused of incapacity, right? So it can happen that one of the parties was incapable or is alleged to be incapable, or both parties are. So we send the parties that were incapable, allegedly, a link to the MCMI psychological assessment tool. They will do that online, and then you will get the results of that. You will also get access to the acts of the case, so you will be able to read the testimony, the declarations of the parties and the witnesses, and then you will have an online meeting, either phone call or video conference, with the parties. Mind you, sometimes the respondents don't want to participate, so you will not be able to have this interview. Okay, and then we will give you a template for your psychological report, which is basically a few questions that you need to answer for us, and with the information from the MCMI, the information from the acts of the case, and the information that you gather directly in the interview with the party or parties, you will create that report and send it to us. When you do that report, you will need to look at the grounds of the case. So you could have cases of grave defect of discretion of judgment or cases of incapacity to assume the essential obligations. Those two grounds can be in one party or in both parties, and each case may be different with this possible combination. So one ground or two grounds on one party or on two parties. So minimum one ground on one party, maximum the two grounds on the two parties. Okay. The main question is whether there was an anomaly or not. And by the way, you don't have to always find an anomaly. Sometimes you will examine the person and you will consider, well, honestly, there is no grave anomaly here. Then your legal duty is to say, well, I don't think there is a big psychological anomaly here. So you gotta write that down, okay? We need you to explain what the anomaly is. We need you to explain it in a language that we can understand. We need you to give us all the information that you can share with us about the anomaly. In this sense, we don't need so much that you give the name, the DSM-5 name of the anomaly, and that you explain the typical manifestations of the problem, right? What we need is how this anomaly came to happen, so sources of the anomaly in the life of this person, what symptoms were present at the time of the wedding, how grave it was at the time of the wedding, and what effects the anomaly had in the intellect and will of the person, right? So it's not, for instance, it's not so important for us that you say major depression as to explain, okay, what is the concrete meaning in this case? What did it mean for this person in terms of their ability to understand and to will? Okay. By the way, the DSM-5, which is a great tool, is not binding for us. Okay. So, for instance, we are not bound by homosexuality was considered an anomaly or a psychopathology in prior editions of the DSM-5, and it's not anymore. So we don't we are not bound by the limits of the DSM-5. So for instance, in a case of incapacity to assume, certainly being homosexual can have serious effects in your ability to give to your spouse in a heterosexual marriage the right to sexual intercourse, the capacity to remain faithful, etc. So without getting into any political problems, etc., please be very clear that you are not bound by the limits of the DSM-5. What you need to do is to tell us if there is something anomalous in the mindset of the person at the time of the wedding, always from the perspective of the Catholic anthropology. It's important that you give us some understanding in your report of how you argument, how you reach these conclusions. So if you say that the person is depressed, or that the person has bipolar, or whatever it is, it's important that you tell us why you think so, right? So because it's not the same if one witness said one thing, so I am reaching this conclusion that all the witnesses agree on this, and the MCMI says this, okay? It shouldn't be a collection of pieces of evidence, right? Like this witness says this witness says this witness says this witness says this. Okay, you can and you should refer to the testimony, but not in like making a florilegium or a collection of sentences. It's more about, well, all the witnesses agree in the fact that this and that happened, therefore I believe that okay? And finally, the technical language, please avoid difficult jargon of, we all have our own language, right? But we gotta be mindful that there are people who are not in our field. So in this case, we are not experts in psychology, so we need pointers. So I don't know, there are difficult names out there for psychological problems. Please explain to us in a way that someone who, we're judges, we're people of, how to put it? We are not simpletons, but also we're not experts. So be mindful of that. And finally, I would like to go over with you this report of the court expert template that you will have. The report has some parts that you need to change, like including your name, the case name and protocol, the date of the report. It has a HIPAA disclaimer, and then you need to write the grounds, etc. And there are 8 questions. Right? The first one is about the genesis of the psychopathology, if there is anything. So facts from childhood, adolescence, and youth that could have impeded a healthy psychological development. The second question is, could you identify symptoms, the symptoms of the psychopathology? Third, to what extent are you able to comment on a diagnosis? Fourth, was this anomaly present at the time of the wedding? And then 5 and 6 are questions regarding 1085-2 and 1085-3 respectively. So if it is a case in which you have both grounds, you should keep both questions and answer both. If it is a case of only 1085-2, you only keep question 5 and erase question 6. And if it is only 1085-3, you take out question 5 and answer only question 6. Okay. And finally, question 7 asks if, in your expert opinion, the problem has been solved, has been overcome, because in cases of incapacity, if we declare the nullity due to an incapacity, the law mandates us judges to forbid the people from entering a new marriage until it is certain that the problem has been solved, so that a new marriage is not invalid because of the same reasons, right? That's what we call a vetitum. Finally, there is a last question if you have something else to ask. So this is the introduction to your role. We're very thankful that you're willing to help. We really need you. And this is a beautiful service to the Mother Church that affects directly the life of the people. Practically speaking, you will have the help of Dr. Anhao, our in-house court expert, She will be there for you if you have any questions about technical stuff with psychology or how to address the clients, etc. You will have, of course, my own help. If you have any canonical questions, I'm here for you. Just shoot me an email, text me, or call me. I'm available for you. And for the actual work, it will be the moderator of the tribunal, Angela Pratt, who will be sending you cases and giving you practical directions, and she will be the one that you will submit your report to. Again, thank you very much. We're very happy that you're willing to help and looking forward to working with you. Have a good day.